Hello everyone, and welcome to the April 2026 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case law update is on the published Court of Appeals opinion that was issued on March 16, 2026 of Kermit Lamarck Copeland versus Allstate Insurance Company. The second case we will discuss is another published Court of Appeals opinion that was issued on March 25, 2026 called Northland Radiology, Inc. versus Allstate Fire and Casualty Insurance Company. Lastly, we will focus our discussion on the trending topic of PIP litigation pertaining to equitable rescission of a policy. In particular, there is a related very recent published Michigan Supreme Court decision that was just issued on April 20th, 2026 called Janice Sherman versus Progressive Michigan Insurance Company and John Doe that I will discuss. The first case we will talk about is the published Court of Appeals opinion that was issued on March 16, 2026 of Kermit Lamarck Copeland versus Allstate Insurance Company. This case centers on priority of insurers under the No-Fault Act, and more specifically the legal determination of domicile for purposes of assigning responsibility for PIP benefits. The key issue is whether plaintiff was domiciled in his sister's household at the time of the accident, which would then shift liability to her insurer, or whether no such domicile was established, making the assigned insurer responsible. The facts of this matter are that plaintiff, Kermit Lamarck Copeland, was a homeless individual for approximately 10 to 15 years prior to the accident. He had briefly lived with his sister about 17 years earlier, but had not resided there since. Despite this, he continued to use his sister's address for mail and identification purposes because it was a stable address. In February 2021, plaintiff was injured as a passenger in a hit-and-run motor vehicle accident. Neither he nor the driver had insurance. While recovering, plaintiff primarily stayed at another location, though records inconsistently reflected his sister's address. Plaintiff then applied for PIP benefits through the MACP, and the claim was eventually assigned to Allstate. The sister's household had an active policy with auto owners insurance, raising a priority dispute based on whether plaintiff was domiciled there at the time of the accident. Plaintiff then filed suit seeking PIP benefits after delays in claim assignment. Once Allstate was assigned as servicing insurer, Allstate moved for summary disposition under MCR 2.116C10, arguing that plaintiff was domiciled with his sister, making auto owners the higher priority insurer. The trial court agreed with Allstate, concluding that plaintiff was domiciled at his sister's address and no genuine issue of material fact existed regarding domicile. Accordingly, the trial court granted summary disposition in favor of Allstate. Plaintiff then appealed this decision to the Court of Appeals. Upon appeal, the Court of Appeals stated that domicile is a person's true, fixed, and permanent home to which they intend to return, and a person may have only one domicile at a time, and it continues until a new one is established. To determine domicile, Michigan courts apply the Workman and Dairyland multi-factor tests. As to the Workman factors, the court found that most factors weighed against domicile at the sister's home. As far as intent goes, plaintiff expressly stated he had no intent to live there. For residence, he had not lived there in over a decade, and the familial relationship was informal and distant. And there was also evidence suggesting possible prior residences and homelessness. These factors largely undermine the conclusion that plaintiff was domiciled at his sister's address. As to the Dairyland factors, the court acknowledged some factors favoring domicile, like use of the sister's address for mail and identification. However, several factors weighed against domicile, including there were no personal belongings at the home, no room maintained for plaintiff, and no financial dependency on the household. Overall, the factors did not strongly support a finding of domicile, just like the Workman ones. The court ultimately rejected Allstate's argument that an affidavit from plaintiff towards his domicile should be disregarded as contradictory. Instead, it held that the affidavit supplemented rather than contradicted prior testimony. It introduced additional facts suggesting alternative domiciles or none at all, and this created a genuine issue of material fact. The court emphasized that domicile is generally a question for the jury, especially where facts are disputed. Here, competing evidence regarding plaintiff's living situation precluded a legal determination at the summary disposition stage. The court reversed the trial court's granting of summary disposition, held that a genuine issue of material fact exists regarding plaintiff's domicile, and remanded the case for further proceedings. Judge Kelly wrote separately to question the assumption that every person must have a domicile. He suggested that homeless individuals may lack a traditional domicile entirely, and courts should avoid defaulting to a prior residence when facts do not support doing so. This concurrence highlights a potential shift in how domicile may be analyzed in future no-fault cases involving homelessness and how complex the issue really is. The second case we will discuss is the published Court of Appeals opinion that was issued on March 25th, 2026, called Northland Radiology, Inc. versus Allstate Fire and Casualty Insurance Company. This case addresses the validity and effect of opting out of PIP medical coverage under the No Fault Act, specifically MCL 500.3107D. The central issue is whether an insured's election to opt out of PIP medical coverage is effective when all statutory requirements are not satisfied, and what consequences follow if the opt-out is invalid. This case arises from a February 1st, 2023 motor vehicle accident involving Dwight Turner, who was injured and later treated by Northland Radiology. Turner assigned his rights to recover PIP benefits to the provider. At the time of the accident, Turner did not have his own no-fault insurance policy. He allegedly lived with his mother, and the mother held a no-fault policy issued by Allstate. When the mother renewed her policy in September of 2022, she selected option 6, no PIP medical coverage, certifying that she had Medicare Parts A and B, and all resident relatives had qualified health insurance or other PIP coverage. However, Turner, the mother's alleged resident relative, did not have qualified health coverage. His Medicaid coverage did not qualify under the statute. Northland Radiology sought payment for services rendered to Turner, arguing that the opt-out was ineffective and that the policy should provide PIP benefits. Northland Radiology filed suit seeking payment of PIP benefits. Allstate moved for summary disposition under MCR 2.116C8 and C10, arguing that the mother had validly opted out of PIP medical coverage and thus no PIP benefits were available under the policy. The trial court agreed with Allstate, holding that Allstate was entitled to rely on the mother's representations in the opt-out form, and the opt-out was effective. The court granted summary disposition in favor of Allstate and denied reconsideration later on. Northland Radiology appealed to the Michigan Court of Appeals. Under MCL 500.3107D, an insured may opt out of PIP medical coverage only if all statutory conditions are satisfied, including the named insured must be a, quote, qualified person, unquote, i.e. have Medicare Parts A and B, and all resident relatives must have qualified health insurance or other PIP coverage, and the insured must provide proof of such coverage. The court found that although the mother satisfied some requirements, i.e. she was a qualified person with Medicare coverage, and she executed the opt-out form, she failed to satisfy all statutory requirements because Turner, a resident relative, did not have qualified health coverage. The mother did not provide proof of such coverage for Turner. Because the statute requires all conditions to be met, the court found that the opt-out was ineffective as a matter of law. The trial court had ruled that Allstate could rely on the mother's certifications in the opt-out form. The Court of Appeals rejected this reasoning, hold that the statute did not permit an opt-out based on insurer reliance or equitable rescission. The court ultimately rejected the idea that coverage could be selectively applied to certain individuals. Instead, the statute requires that the entire policy provides unlimited PIP coverage if the opt-out is ineffective, and that includes here to Turner. The court reversed the trial court's grant of summary disposition to Allstate and held that the opt-out was ineffective, determined that, absent other defenses, the policy provides unlimited PIP medical benefits, and remanded the case for further proceedings. The court declined to address whether Allstate could assert defenses such as fraud on remand. In a concurring opinion, Judge Wardle highlighted policy concerns and unintended incentives, noting that insureds may benefit from reduced premiums while still triggering full PIP coverage if the opt-out is later deemed ineffective, and insurers may be incentivized to conduct extensive investigations into household members' coverage. The concurrence suggests that legislative clarification may be needed to address these consequences. I want to now focus our discussion on the trending topic of PIP litigation pertaining to equitable rescission of a policy. Specifically, there is a very recent published Michigan Supreme Court decision that was just issued on April 20th, 2026, called Janice Sherman versus Progressive Michigan Insurance Company and John Doe, that I wanted to discuss with you all. This case addresses rescission of a policy based on material misrepresentation and clarifies the proper standard of appellate review for rescission decisions. The central issues are whether the insurer was entitled to rescind the policy due to the insured's misrepresentations, and how courts should evaluate and review equitable remedies like rescission versus reformation. The facts of this case are plaintiff Janice Sherman applied for a policy with Progressive in November of 2020. In her application, she listed her residence and vehicle garaging location as Clinton Township and identified herself as the only household member and driver. In reality, plaintiff primarily resided in Detroit at the time of the accident. Her vehicles were garaged at different locations, including Detroit, and she had undisclosed resident relatives living with her. In July of 2021, plaintiff was injured in a motor vehicle accident and sought PIP benefits. Progressive investigated and determined that she had made these material misrepresentations, which would have increased her premium by over 80%. Progressive then denied coverage, rescinded the policy ab initio, and refunded all premiums paid. Plaintiff then sued, alleging wrongful denial of PIP benefits and breach of contract. The trial court denied Progressive's motion for summary disposition and instead reformed the policy, requiring plaintiff to pay additional premiums to reflect accurate information. The Court of Appeals reversed, holding that rescission, not reformation, was appropriate, and that Progressive was entitled to summary disposition. The Michigan Supreme Court granted review to address the proper standard of review for rescission deadlines, whether the Court of Appeals correctly applied that standard, and whether remand was required for further balancing of equities. First, the court clarified a key doctrinal issue. When rescission is raised on summary disposition, the appellate court first reviews de novo whether a genuine issue of material fact exists, and then reviews the trial court's decision to grant or deny rescission for an abuse of discretion. The court held that plaintiff made material misrepresentations regarding garaging location of vehicles and household residents and drivers. A misrepresentation is material if it would affect the insurer's decision to issue the policy or the premium charged. Here, the undisputed evidence showed that accurate information would have substantially increased the premium, making the misrepresentations material as a matter of law. Importantly, intent is not required. Even innocent misrepresentations can justify rescission if material and relied upon. The court reiterated that rescission is an equitable remedy, not automatic. Courts must balance the equities in deciding whether rescission is appropriate. However, in this case, Progressive engaged in no wrongdoing, plaintiff alone made the misrepresentations, and Progressive relied on those misrepresentations to issue a lower cost policy. Thus, the equities were entirely one-sided in favor of Progressive. The Michigan Supreme Court ultimately affirmed the Court of Appeals decision, holding there was no genuine issue of material fact regarding plaintiff's misrepresentations. Progressive was entitled to rescission of the policy, and the trial court abused its discretion by ordering reformation instead. As a result, the insurance policy was properly rescinded ab initio, and plaintiff was not entitled to PIP benefits. Overall, this case strengthens the insurer's ability to rescind policies where material misrepresentations affect underwriting, while also clarifying how courts should analyze and review such decisions. That concludes the April 2026 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.